Hello my dear friends and welcome to Study IQ. I am Joycey Joy and today in this lecture we will analyze the validity and relevance of defamation law in India. Let us start with the current affair. What is the current affair? The Me Too movement has gained momentum in India and many celebrities, many well-known people are coming up with allegations in this movement. So as a response to these allegations, many people are coming up in the form of defamation cases. So once a person is alleged of a sexual offense, what he does, if he has the power or if he has the money to approach a court of law, he will go up with the defamation cases. So it is important for us to relook at the relevance and validity of the Indian defamation law. We will see and analyze the defamation law in India, the status of the law and how relevant it is, and we will also see what are the challenges in the present law. Let us start. Let us look into some recent developments in the defamation law. So, many accused of sexual harassment have leveraged criminal defamation law to strike back to these allegations. So, for example, MJ Akbar, he made a criminal defamation complaint against Priya Ramani. Again, another example is Alok Nath. He filed a criminal as well as civil defamation complaint against Vinta Nanda. So, from all these examples, we see that well-known people or celebrities or politicians, they come up with defamation cases against the allegations made against them. So, that is why it is important for us to analyze Indian defamation law. Now, what is the dispute in the defamation law? Defamation law is aimed to be a balancing tool, which means that there should be a balance between the freedom of speech and expression and also the right to be respected. So, these two things need a balance in between, and no legal system can allow false statements to be made publicly with impunity. So, there should be a balance between these two rights and defamation law should act as a balance. So, there is a dispute going on that defamation law is favorable to the powerful people. So, we will analyze whether this argument is right or wrong. We will also see what are the challenges in the defamation law in India. But before going on to the challenges, let us analyze what is the defamation law in India, how is defamation dealt in India. So, we will see it in detail. In India, defamation is both a civil offence as well as a criminal offence. First, let us see how it becomes a civil offence. A person defamed can move either to the High Court or to the trial court. The complainant can seek damages in the form of monetary compensation from the accused. So, this is the civil offence. Now, coming to the criminal offence. So, criminal offence means IPC has mentioned defamation. So, Indian Penal Code provides a defamed individual to move a criminal court. So, he can approach a criminal court against the defamation. And defamation under IPC is a bailable, non-cognizable and compoundable offence. It means that no police officer can register a case without a court's permission. So, prior permission from a court is required to register a defamation complaint or case. And compoundable means that a criminal court can drop charges if the victim and the accused enter into a compromise. This compromise can be even without the notice of the court. So, if the victim and the accused comes into a mutual understanding, the case can be dropped. So, that is why it is called compoundable. And under IPC, section 499 and 500 deals with criminal defamation. And according to the section 499 and 500 of IPC, a person found guilty can be sent to a jail for 2 years. So, this is the existing defamation law in India. It is both of criminal as well as civil nature. Now, we will see what are the concerns with the defamation law in India. The first one is regarding the relevance of the defamation law. India's criminal defamation law restricts or silences the freedom of speech and expression, and this is one major criticism of Indian defamation law. So, let us see the Indian criminal defamation law. As we have discussed, it is provided under section 499 and 500 of IPC. So, under section 499, it provides an ideal weapon for powerful individuals to silence critical or inconvenient speech. We have discussed in the beginning of this lecture that if a person is powerful, money-wise or authority-wise, he can file a criminal case against the allegation made against the person. So, Section 499 of the IPC is a weapon for powerful individuals to use it against any inconvenient speech made against them. And this Section 499, if we look at the background or genesis, we will see that it was introduced by the British under the colonial rule in order to suffocate political criticism. So, the relevance of this defamation law is the first challenge. The second one is regarding the conviction. In most of the countries, defamation is only a civil wrong. But in India, it is not only a civil crime but also a criminal case. So, when defamation becomes a criminal offence, we have learned that a jail term of up to 2 years can be given to the person. So, under the criminal offence, it entails social stigma as well as potential jail term. This is unlike in other countries. Now, the process of the defamation law being implemented, the process is the third concern. So, if a person want to establish a complaint, the prima facie case of defamation can be established with very low threshold. That means it is very easy for a person to lodge a complaint against another person for causing defamation. So, what is the requirement? A person, that is a complainant, should only show that an imputation has been made that could reasonably be interpreted as harming the reputation of the person. So, it is very easy for a complainant to lodge a complaint under the criminal case. Now, for the accused, the person who is accused of defamation, that person will get an opportunity to defend his side only after the trial begins. So, we can say that the process is favorable for the complainant, and even after the trial begins, trial is a very long process. So, this long-term trial process must be undergone by the accused. So, it is difficult for the accused and the process is easy for the complainant. So, we can say Indian defamation law is favorable for the complainant. And fourth concern is regarding the disproportionality. Under the Indian defamation law, the defendant or the complainant needs to only show that his or her statement was true. So, that is the only responsibility of the complainant. But in case of the accused, what the accused has to show, he or she will have to show that her or his statement was true in the public interest. So, for the accused, it is dual challenge. It must be proved true and it must also be proved that the statement was made in public interest. So, we can say that in civil cases, the legal system is more advantageous towards those at the receiving end, and in the criminal process, it is more harsher towards those who have to undergo the process, because criminal process is long term, the trial is long term, the accused will get an hearing opportunity only during the trial. Now, if we look at the constitutionality of the criminal defamation, in 2016, it was challenged in the Supreme Court. So, in Supreme Court in 2016, it was challenged whether the defamation law is constitutionally valid or not. But this challenge was ignored by the Supreme Court, and the Supreme Court held that Section 499 of the IPC was constitutional and it is important to protect the individual's reputation. The disproportionality that we have discussed, it was not considered by the court. So, that is also another concern. Now, if we look at the present scenario, we will see that there are new challenges in the defamation law in India. In India, the defamation law or the background has much changed in the last 2 years, especially after the Me Too movement. So, after the Me Too movement, we will see there was a significant change in this area. So, we have seen when an allegation is made under the Me Too movement, the powerful men will file criminal defamation cases in order to silence this, and this remains a major concern. Now, we will see how the US political system has dealt with the defamation law. In the 1960s, the US Supreme Court made substantial modifications in the defamation law in US. So, what was the modifications aimed at? It was aimed to ensure that it could no longer be used as a tool to harass or blackmail. So, misuse of defamation law was brought under control in the US economy. For example, in case of journalists could go about their job without fear. They can make statements. That is a part of their job. So this shall not be included under the defamation law. But the court also held that even though there is a freedom of speech and expression, it does not mean that the person has a freedom to make wrong or false statements. That would be punishable under the law, but more importance was given to the freedom of speech and expression. Now, what is the way ahead for India? India and Indian defamation law is gaining momentum, especially after the Me Too movement. So, now what has to be done? We should ensure that the defamation law is no longer a tool of the powerful to blackmail or harass and silence the inconvenient speech. So, the legal system, that is law and judiciary, and also the government, that is the legislative body, should ensure that the defamation law should not be used as a tool that will be used to harass or blackmail any inconvenient speech. And also, for this purpose, the courts, especially the Supreme Court of India, should revisit the constitutionality of the criminal defamation. We have seen that in many countries, defamation is only a civil case, but in India it is both a civil as well as criminal case. So, the Supreme Court must revisit the constitutionality of defamation being a criminal offence, and there can be wider interpretations for Section 499, and this can be provided by the Supreme Court of India. So all this must be considered both by the judiciary and also by the legislature, and ideally, as the defamation law aims at, it should provide a balance between freedom of speech and expression and also right to reputation. You can find the PDF of this lecture on my Facebook page. I wish you all a very good day. Thank you.